Good afternoon, everybody. Welcome. Thank you for tuning in and sharing a piece of your day with us. To those of you who were with us last week, welcome back. And for newcomers, we're really thrilled that you were with us. I'm Jamal Rossi. It's my honor to be the Dean of the Eastman School of Music. And truly, I'm thrilled to welcome you to the event today. In thinking about this, Rachel Roberts and I were talking about the fact that during our centennial, we spent a lot of time looking back and thinking about the history of the school and the history of education and Eastman's role in that. But we also spent a lot of time thinking about the next 100 years and the future. And while it is impossible for any of us to really have a keen handle on what the future looks like, one thing is for certain, and that is that technology and artificial intelligence and Gen AI are going to play an ever increasing role in what we do in music, in education, and likely all of society. So this topic today is so vitally important. Um, we just have to come to grips with how do we embrace it today as musicians? How do we embrace it as an artistic tool? And how do we make certain that we are utilizing it a way that will benefit musicians as well as enhance and enrich society? Interestingly enough, at lunch today, I had a chance to read an article in the Chronicle of Higher Ed that says AI will shake up higher ed. Are colleges ready? It's a great question, and maybe we will learn a bit more about that today. So I want to offer my thanks to our panelists today, and I know you're going to find their insight and their scholarship and their experience fascinating. Ari Solotov is an entertainment and intellectual property lawyer who also is a faculty member teaching in Eastman's Masters of Music Leadership degree program. Jonathan Harrington is an assistant professor in the Department of Philosophy at the University of Rochester's School of Arts and Sciences. John is also a member of the National Science Foundation research team. And you'll hear from some esteemed guests that we're happy to have join us virtually as well. Joseph Fishman is a professor of law at Vanderbilt University, whose scholarship focuses on the relationship of creativity and the creative process as it relates to intellectual property. And Judith Fennell is a musicologist who owns and runs a music consulting firm and who has served as an expert witness, a forensic musicologist, on trials involving music copyright infringement. And last, but certainly not least, a huge thank you to my dear friend, Dan McIntosh, an entertainment lawyer and a member of Eastman's National Council. We really have Dan to thank for bringing together this group of esteemed leaders to engage in the presentation and today's discussion. Finally, I want to offer my most sincere thanks to my colleague, Rachel Roberts, Eastman's Director of the Institute for Music Leadership, for all of her efforts, as well as the entire team of colleagues in the Institute for Music Leadership for putting together this important seminar and exploring legal and ethical considerations between music and AI. It's now my pleasure to turn the screen over to Rachel. Thanks so much.
Thanks, Jamal. And thank you to all of you for being here today. We are thrilled to continue this presentation, second in the series. And as we all know, the world of Gen AI continues to change and evolve every day. This symposium is about this particular moment in time, where we are, what we are learning, and where possibilities are for the future. As you heard, this is the second of the series, and today is specifically focused on exploring legal and ethical considerations between music and AI. These topics have come about in our research, a National Science Foundation grant to support the project titled Towards an Ecosystem of Artificial Intelligence-Powered Music Production, or Team Up for short. This research has three objectives: to create an open access framework enabling musicians and AI researchers to collaborate in developing new music production solutions, to understand both advances and challenges that may arise from using AI for music production. And lastly, to provide new learning opportunities to empower current and future musicians to utilize technology better. At this moment, we are halfway through this 3-year grant-funded project. We have embarked on in-depth interviews from musicians in various fields across the country. We are testing out 2 college class learning experiences, focusing on developing skill sets with AI. And we are actively planning for a high school summer day camp experience to work with students on their utilizations and adaptations of Gen AI. Today, we've broken the next 2 hours into a few distinct presentations, which Dan McIntosh will be introducing to you. We'll also have a few moments of reflection and audience participation from you, along with a Q&A at the end of the presentation. Before this, however, I'd like to give just a quick overview of last week's presentation. Some of you may have joined us, and for those of you that haven't, this is for you. We first began with Eastman professors Christopher Azara, providing a foundation on what creativity is, how to think about how to define what creativity means to each individual person. We then saw 2 brief presentations by our NSF research collaborators. Yu Jung Han, a postdoctoral associate at U of R's Warner School of Education, who also works with the Center for Learning in the Digital Age, provided a fantastic introduction to what generative AI is. And Benjamin Guerrero, an assistant professor of music at Eastern Mennonite University, teaching music tech classes at James Madison University, and ABD here at Eastman School of Music, also finishing his dissertation and a member of the NSF team, provided examples and insights of how generative AI is being incorporated into music today. We then transitioned to a preview of our NSF research data. Dr. David Miller, an associate professor at Warner School of Education and associate director in the Center for Learning in the Digital Age, and Dr. Blair Kerner, an assistant director here at the Institute for Music Leadership. They both conducted many of the interviews for this research over the last few years, and they provided the initial findings and insights of this work. And we concluded with a robust Q&A from many of the participants in the session. If you are interested in any pieces of this presentation, I'm dropping a link in the chat, which takes you to the recording. Please feel free to reference this, to share this with your friends or colleagues or students or anyone that might be interested. We will also be posting today's video for everyone by the end of this week. And one housekeeping item. If at any time you have questions throughout today, please type them in the chat directly to me. I'm sitting right here next to Dan, and I'll help facilitate these questions being asked towards the end of the session. And as we begin today, I'm very pleased to now turn over the facilitation roles to Mr. Dan McIntosh, who helped to curate and plan today's panel.
Thank you, Rachel. It's a pleasure to be here. I want to thank Eastman School of Music and you and Jamal for your support with this program. I would have to say I am not responsible for its content, certainly not solely. Rachel has been leading this team of National Science Foundation grant scholars and researchers and has produced what was the first part of this program. If you've not had an opportunity to watch it yet, I would urge you to, because I think in and of itself, it's a very valuable window into what's happening and what's coming from the standpoint of intellectual property. A term we hear a lot. We hear it on television news. We read about it in the newspaper. We're going to focus today on what it means for the arts generally and specifically music. When I was thinking about the program this morning, I thought, you know, I should have come up with theme music. And then I thought, what would I use for a theme? I think what I would use is one of my favorite Burt Bacharach tunes, What's It All About, Alfie? because I think that's really what we're constantly trying to understand. Artificial intelligence is obviously a term which describes a technology which has existed a long time in our adult lives. Certainly not when I was young did I anticipate anything like this. But now here it is, and we're going to try today to talk about how has the law and will the law react to this? How will the music industry react to this, and how is it reacting now? And what can we say about what sort of controls, guidelines it would be a good idea to have in place? And what are things that ought to be left to the marketplace of artistic endeavor and creativity? So our first speaker, who I want to introduce, is Joseph Fishman, as Jamal indicated, professor of law at Vanderbilt University. He is emblematic, I think, of the cross subject matter expertise and experience of all of our panelists. He's a professor of law. He's a professor specifically of intellectual property law, specializing in, amongst other things, copyright. Copyright, of course, applies both to text, to written, but also music. And he is, I think, certainly just on the basis of his article of 5 or 6 years ago at the Harvard Law Review called Music as a Matter of Law, the national expert that I know of in how to apply copyright to music. He's a graduate of Harvard College, where he majored in music and religion. He's got a degree in musicology from Cambridge, and he's a graduate of the Harvard Law School. Let me now introduce and turn the program over to Professor Fishman.
All right, thank you very much for that introduction. And welcome to everyone. So I'm, like Dan said, here to introduce the big legal questions that generative AI is raising in the music industry. And I want to emphasize that word questions because much of what I'm going to be covering does not really have a definitive answer yet. Given the topic, I thought it would be fitting to let DALL-E, a generative AI program developed by OpenAI, the same company behind ChatGPT, to whip up some images for my slide deck. So let me share that with you now. One moment. And there we go. So what you're looking at is the cover slide here. And my prompt was to generate an image showing how a composer could use generative AI to help create a new piece of music. The composer works at the Eastman School of Music. So you'll need to let me know if you see anything in this image that is suggestive of the Eastman School of Music. If so, I missed it. But this is what it came up with. So I'm going to start with a whirlwind tour of how US copyright law applies to music. And I'm then going to tee up what I think are the three biggest questions that we're facing right now. Can a human composer acquire a copyright on music if relying on generative AI at some point during the composition process? Does training a generative AI model on copyrighted works, including sound recordings or music lyrics, count as a fair use that does not require a copyright license? And then finally, does cloning a recognizable singing voice without the singer's consent require a license for publicity rights? First, though, I want to plug that the Copyright Office is conducting a monumental study of these issues and more. Over this past summer, they put out a notice of inquiry and received over 10,000 individual submissions that they are still going through. The study that is supposed to come out later this year is going to cover a range of topics, right? The use of copyrighted works to train AI models, the copyrightability of material generated using AI systems, and a lot of the same stuff that I'm going to be talking about today. But I really want to highlight for you that if you are interested in what the US government is doing in this space, go to www.copyright.gov/AI, which is like your clearinghouse for all of the latest developments within the Copyright Office. So let's start with some music copyright basics. And here I asked I asked DALL-E to generate an image of an enthusiastic law professor teaching about music copyright. So there I am. Copyright is exclusively federal, not state. Let's start there. And both the rights and limitations on those rights are set out in a statute called the Copyright Act. They're also heavily supplemented by decades and decades of judge-made law interpreting that act. Both musical compositions and the sound recordings of those compositions are among the different categories of authorial works that are eligible for copyright. And here I want to really emphasize it's important to distinguish between the underlying musical work and any sound recording that embodies the work that's within the recording. Each is its own separate category. Each can receive its own copyright. So to give you a quick example of this, if we took All Along the Watchtower, originally recorded and written by Bob Dylan, and let's just assume that he's the only copyright owner involved. There's no record label. There's no music publisher. So if you're listening to Bob Dylan's recorded version of it, you have a musical work and you have a sound recording. Bob Dylan is the copyright owner of both. If you are listening to Jimi Hendrix's version, you have another sound recording, but you have the same musical work for copyright purposes. In fact, there are tons of other recordings of All Along the Watchtower, and each of them implicates the same underlying musical work, but a different sound recording copyright. Even if you look there at the bottom, a different recording by Bob Dylan himself, that would generate a different sound recording copyright. So how do you get one of these things? Today, all you need to do is to satisfy a pretty minimal originality standard, and then to go and fix the work in some kind of tangible medium. That could be writing notes on staff paper. It could be recording something to a computer hard drive. Anything will do that's tangible. Once you've done that, the second thing you need to do is nothing. You have a copyright. Copyright vests automatically. You don't need to publish it. You don't need to apply to the government. You'll hear me talk about the Copyright Office. That's a government agency, but their main job is to register applications for copyrights that already exist. The office does not actually grant copyrights, and it isn't in charge of making substantive law the way that some other federal agencies are. Copyright law is made by Congress and the federal courts. So if you own a copyright in a work, it means you have a bundle of exclusive rights to engage in certain activities with that work. So you have the exclusive right to reproduce the work in copies. You have the exclusive right to adapt the work into other forms, what the law calls a derivative work. You have the right to distribute copies. You have the right to perform the work publicly. You have the right to display the work publicly. And if anybody else wants to do any of these things, they need to clear the rights by getting a license. That, in a very, very teeny tiny nutshell, is what copyright law is and what it's doing here. So that brings us to the first of our big questions here, which is how much human creativity do you need to own a copyright on a work that generative AI puts out? And what you're looking at here is an image that was a response to my request to generate an image showing a judge sitting alone in chambers. The judge is having trouble deciding whether a human composer can receive a copyright on a song that the composer created with the assistance of generative AI. And I think it pretty much captured the mood. So for about 200 years, copyright law has not had to worry about questions relating to people's creative processes. Copyright doctrine focused on authors' end products, not the processes through which they were produced, right? It didn't have to. If you saw a novel or a symphony just lying on the ground, it had to have been written by a human being, right? Now, all of a sudden, we can't assume that anymore, and the law is trying to play catch up. So the Copyright Office is getting the first crack at trying to tease out whatever it can from existing law before we get further guidance either from Congress, the courts, or both. So in the meantime, it issued guidance to registration applicants in March of last year. And what it said there was this standard. Now, if you look at the last sentence here, in each case, the Copyright Office said, what matters is the extent to which the human had creative control over the work's expression and actually formed the traditional elements of authorship. That is the standard for whether a human is a copyright owner, notwithstanding the use of some generative AI tool in the creative process. What is going to satisfy that standard is very much up for grabs. And we don't have a real test case yet in the music space, but we do for visual art, and it might be instructive. The image that you're looking at here was an output from a generative AI program called Midjourney. It actually won the 2022 Colorado State Fair annual fine art competition. And the person who got Midjourney to generate it tried to register it for a copyright, and the Copyright Office said it wasn't eligible for one. Now, it said that in spite of the fact that this wasn't like the images that I'm throwing up on the screen for my slides, where I just gave it a single prompt or maybe two. This one, the human being behind it went through 624 iterative prompts to try and get exactly the image that he wanted. Copyright Office said it didn't matter. And its reasoning was, and I'm quoting here, when an AI technology receives solely a prompt from a human and produces complex written, visual, or musical works in response, the traditional elements of authorship are determined and executed by the technology, not the human user. Now, this is a controversial decision. On the one hand, I think one might ask, how is it possible that going through 600 something times trying to fine tune what an image looks like isn't an authorial act? On the other hand, if I were to go to some random image generator and press the generate image button 600 something times, and then on turn 624, I finally find the image that I like, and I say, that one, I want that one. Am I the author of the image? Right, so those would be the two sides of that debate. Still very much open for debate. That brings me to the second of the big questions, which is training a generative AI model fair use? And here I asked DALL-E to give me an image of a machine eating hundreds of pages of musical notation. Why I asked it to generate that particular image will become clear in just a moment. So this is probably the issue that's getting the most headlines in legal circles because it affects the whole infrastructure of how generative AI models get built. And the question here is whether the companies who build these models are liable for copyright infringement. And there are different legal theories under which that answer might be yes. One is, well, it could be because the output of the models is infringing. If AI is simply regurgitating an existing work in response to a prompt, what has come to be called memorization of the work, that's really just a very complicated way to reproduce a work. And I'm going to refer to that as infringement on the output side. But it could also be because the way that these models are trained is infringing regardless of what they generate. And I'm going to call that theory of infringement on the input side. And that one requires a bit more explanation. So the thing to remember is that all of these AI models, all that they're doing is making a statistical inference about what element of a requested output is the best fit to follow after another element, given the prompt that's been given. So what word best follows a previous word? What pitch best follows a previous pitch in a piece of music? And that inference is based on mining a large corpus of materials in order to discern patterns. That's what training the model means, if you hear that term. The machine gets the chance to see what constituent pieces of human expression tend to travel together. It's all about pattern recognition. And here's where copyright comes in. That training process involves copying the works that the machine is ingesting. You, as the end user, may not experience those copies, but copyright law treats them as copies all the same, even though they really only exist underneath the hood, so to speak. So on the input side, the question is whether, even if a model's outputs are never substantially similar to any copyrighted work, is that model nevertheless infringing because of all the copying that occurred at the outset while it was being trained? And the legal case that's getting the biggest headlines here, and I no pun intended, is the New York Times lawsuit against OpenAI that's currently being litigated in Manhattan federal court. That's a really important case, but given our music focus and our limited time, I'm going to focus instead on a music case that has gotten somewhat less coverage. There's a group of music publishers that is suing another big AI firm, Anthropic, which developed a competitor to ChatGPT called Claude. That lawsuit is going on where I am in Nashville. And a lot of the allegations in that complaint focus on the output side. I'm showing you a page from the complaint that kicked off the lawsuit. Apparently, if you give this Gen AI model the prompt, "What are the lyrics to I Will Survive" by Gloria Gaynor, it will just spit out the complete lyrics. And it's being alleged here that you don't even have to request a particular song. You just need to give a good enough description of what the song is, what its content is. So if you look here, in paragraph 74 at the bottom, it's alleged that if you prompt it with "write a song about moving from Philadelphia to Bel Air," the model will apparently produce the complete lyrics to the Fresh Prince theme song. These are examples of memorization. And legally, if the allegations are true, I think it should be a pretty clear-cut result. These outputs are unauthorized reproductions. But ultimately, I think the output side of these cases is less interesting. The major developers behind these models are treating memorization as a bug that they want to get rid of. They're not treating it as a feature. They're working on making sure it doesn't continue to happen. It's not a core part of what the tools are supposed to do. The input side, by contrast, is how these models are built from the ground up. And I think that's the issue to watch. Whether the copying that occurs on the input side requires a copyright owner's permission. And that's going to depend on whether the copying is excused as a fair use. So courts assessing fair use in copyright are given 4 factors that are laid out in Section 107 of the Copyright Act. You're looking at all 4 of them, but the 2 biggest ones are number 1, the purpose and character of the use, and number 4, the effect on the potential market for the work. Last year, the Supreme Court decided a fair use case that had nothing to do with AI, but it's become everyone's roadmap for trying to predict how courts are going to analyze the training data question. In the interest of time, I'm not going to go into the details of the dispute in that case, which involved the Warhol image on the left that had adapted a copyrighted photograph of Prince that you see on the right. But here's the key standard that the court announced in that case. On the first fair use factor, that considers whether the use of a copyrighted work has a further purpose or different character, which is a matter of degree. And the degree of difference must be balanced against the commercial nature of the use. If an original work and a secondary use share the same or highly similar purposes, and the secondary use is of a commercial nature, the first factor is likely to weigh against fair use, absent some other justification for copying. So the emphasis here is on whether the challenged use is for the same purpose as the original work or a different one. And there are different ways you could answer that question in the training data context. One answer a plaintiff might give is they're the same purpose. You're copying my song in order to teach a machine to produce a song that's then going to compete in the same market as my song. You're using my song to build its own commercial substitute. A different answer that a defendant would likely give is that they're different purposes. The purposes of training isn't to express anything to an audience the way that the original song was trying to do. Instead, it's to extract metadata about patterns and how words or notes or pictures appear in human-authored texts. That's a completely different purpose. No one really knows how this question is going to shake out. The most we can do for now is keep an eye on these cases and see what the early returns from courts are going to be. Okay, lastly, we're going to talk about voice cloning. And here I asked for an image of a machine making an exact clone of a human singer. Before I move away from this slide, I will point out that weirdly, this seems to have generated what is almost certainly a picture of Donald Trump on the monitor on the right-hand side. And I do not know what that is about. Your guess is as good as mine. So training a machine to sing or to speak in a convincing simulation of a recognizable voice. You probably heard about fake Drake last year, where what seemed to be the latest drop from brand name recording artists turned out to be a machine-made fabrication. There are tons of these popping up across the internet, some really trying to fool people, but others expressly announcing that these are made by a machine, these aren't the real thing. Do you need permission to do any of that? Well, unlike all the previous questions, mimicking someone's voice is not really an issue of copyright, because you can't own a copyright merely in the sound of your own voice. Instead, it's a question about publicity rights, sometimes called name, image, likeness rights, and those vary state by state. I'm going to talk a little bit about California state law just because it has probably the most developed body of law for publicity rights. And there was a famous case in the 1980s involving Bette Midler. Ford Motors wanted to use one of her songs in a commercial, but didn't want to pay for the license, the copyright license, to be able to use the actual recording. So instead, it hired a singer to mimic Midler's voice as closely as possible. I'm going to play for you now just a little snippet from the original Bette Midler recording and then the sound alike that Ford was using. Okay, now here is the Ford commercial.
Now there's a car that just asks to be driven. Mercury is bringing a sophisticated new shape to the American road, introducing Sable.
So this went up to a court of appeals in California, and the court said that this infringed Bette Midler's publicity rights. And it did so because she had a distinctive voice, it was widely known, and it was being used in order to sell a product. In order to sell a product is the key part of that legal holding, because with fake Drake and other AI-produced vocal clones, the voice isn't being used to sell a car or any other product. It's just being used in a song as a song. So can publicity rights be stretched to cover that kind of purely expressive usage? Again, all I can say is stay tuned. My own state of Tennessee looks like it's about to pass a law called the Elvis Act that would do just that. And the last thing that should be on your radar is a federal bill called the No AI Fraud Act that is currently pending in Congress. If enacted, it would be the first ever federal publicity rights law. And it would prevent unauthorized parties from distributing what it calls digital voice replicas, as defined here, an audio rendering that's created or altered in whole or in part using digital technology and is fixed in a sound recording or audiovisual work, which includes replications, imitations, or approximations of an individual that the individual did not actually perform. Nothing in here about it needing to be in a commercial use where you're trying to hawk a car or potato chips or anything else. So the common denominator across all of this, we have more questions than we have answers. There are lots of moving parts, lots of activity in the courts, in Congress, and the Copyright Office. So we'll have a lot to keep our eyes and ears peeled on in the months and probably years to come.
Thank you very much, Professor Fishman. As you can hear, if you're listening in the audience, this is an issue, AI, which raises some new legal questions and which will be looked at and litigated in some instances on an ongoing basis. This is a wonderful window that Professor Fishman has provided into how the law is responding, what kind of cases are being brought. Our next speaker is Judith Fennell. To say Judith is a musicologist would be inadequate. She is a musicologist. She is a forensic musicologist, and she's probably best known for testifying in some very high-profile cases. For example, the lawsuit that was brought by the estate of Marvin Gaye against two popular song composers, Pharrell Williams and Robin Thicke, and involving a song called Blurred Lines. In that case, she testified for the plaintiffs who were successful in obtaining a judgment that the song Blurred Lines infringed the copyright of Marvin Gaye in a song called Gotta Give It Up. Beyond that, though, she is a teacher. She teaches at UCLA. She speaks widely on issues of music, and particularly issues that are of major concern to the music industry. And she's an advisor to many players in the music industry. On the speaking side, she just did a talk, a forum she participated in for TED Talks. And she often is called upon to advise the big guys, the music labels, and even now streaming platforms on what is and what is not permissible from a copyright standpoint. So please welcome to our discussion, Judith Fennell.
Thank you. Thank you so much for your lovely introduction and for your invitation. And hello, everybody. So, excuse me, I'm going to ask Rachel to help me with my slides, and thank her very much for doing so. As we start to go through some of what I believe is important to know from a musical standpoint as well as a legal standpoint. I learned a great deal from Joe's wonderful presentation a moment ago, and I come to it from a slightly different perspective. So I hope this will be of interest to those of you attending. Next slide, please. So as a musicologist, I'm not an attorney, but as a musicologist, over the time of my working life, I've been brought into the discussion about music when often about many reasons, but part of it is because technology has somehow introduced a new way to create or perform music. I think we just lost the slides. Thank you. And how that impacts the legal structure, protecting creativity and also allowing creativity to be expanded to other members of society, etc. So today, thanks to the latest technology that the public is being introduced to over and over again lately, we're talking about AI, but and focusing on that. But this is the intersection in which my work usually occurs, at this intersection of music, technology, and law, and that's what I'll be talking about today. Next slide. Thank you. But I wanted to start by saying that even though AI is the shiny new exciting moment in music technology, I would say that it's really a progression that's been going on since the invention of the printing press. Meaning that once the printing press was invented, not for musical reasons, but it could be used for musical reasons of producing and reproducing musical scores, for example, it meant that more than one copy of something, long before the invention of sound recordings, radio, television, or even most concert halls of the magnitude we see them today. But one by one, a score could be reproduced and learned by more than one musician and exposing more than one composer to it, etc. And this went on for centuries as analog recordings were invented at first, radio, television, every time expanding the possibility of experiencing music and possibly distributing music, but not yet creating music at the beginning. This continued on with the digitization and the change from analog to compact disc recordings, and then sampling, file sharing, etc., till today. And at most of those milestones and many more, music was used sometimes without permission, and then eventually through the court system and other forms of music protection, enforcement of the music industry, was brought into some form of the music licensing system that allowed that new use to be monetized. I actually was privileged to be a testifier at many of these turning points. I testified in many, many cases at the beginning and through the decades now long of sampling, including the early Beastie Boys cases, which had to do with really using other people's recordings without permission at first. And it took a long time for the music industry and the court system to deal with the fact that hip hop was basically invented using other people's recordings. In fact, the early producers would brag that they went into the studio with a crate of recordings and took, pieces off of each recording and made their new recording. And eventually the music industry caught up, as did the court system. And the same thing happened with many other technologies. And I was also asked to testify when ringtones were an issue and monetizing recordings on cell phones, but the record industry was gaining all the profits rather than the music publishing part of the copyright field, as Professor Fishman just explained. So the owners of the underlying work, besides the record label, were not benefiting as much. And I was brought in actually by the National Music Publishers to testify before the Copyright Royalty Board on the sharing of those revenues in terms of the composition and recording income from it. And this continued on with streaming and other forms of sharing music with or without permission. And it was accelerated, especially during the COVID years. Social media and many, many music lovers and some amateurs, some professionals were sharing music they really had not licensed or had no right to use in a legal sense, but did. And then as soon as something became well known or successful financially, the music industry at times would march in with a very strong enforcement. So we're there again. Next slide, please. Let's go back a little bit in time and see where some of this stems from. I'd say that the digitization of music on a broad scale level, really kind of introduced the issue, because suddenly you didn't need to own the master that was in the vault at that time at Columbia Records or other big owners of music recordings. But you basically, if you had a CD at that time, you had the ability to take anything off of another recording and use it. And believe me, it was done. Next slide, please. So I'm bringing you up to the present, though. So the company that I had of all the musicologists who work for me and all, we are faced with these kinds of issues, and we have been for 25 plus years now. Often a record becomes very popular, and suddenly we get phone calls when it wins a Grammy or something that says something like, you know, that synthesizer line in the third bar that they use all through the song is mine, and they used it without permission, and now they just won a Grammy. Or you can imagine the script going along those. And we would get calls all the time, but especially from one side or the other about this, when they were going to either consider legal action or their attorneys would call to say how strong or weak a case this is. And this was facilitated all through, you know, the last 30 plus decades, even though there's a licensing mechanism that was erected by the music publishing and recording industry to avoid these kinds of disputes, but they still exist. Here's a kind of a nightmare for those of you in the audience who are attorneys or thinking of becoming attorneys. In the sense that sometimes the original work gets copied. Sometimes it's the work that's the work that copies the first work that gets copied yet again. And so and sometimes in our musical investigation into the ancestry of a similar musical work, we find that really the ancestor is the grandfather of the two other works. And here's an example of a dispute that occurred. I'll ask for Rachel to play. First, we're going to hear Oscar Peterson, the great jazz pianist, and then we'll hear a portion of his song that was sampled. Then you're going to hear two people who used Mr. Peterson's music, but the second one, Mac Miller, used the way in which Lord Finesse had changed the music. So Lord Finesse added elements to Oscar Peterson. And here's what you're dealing with.
I'm hip to the game. I'll always be the same. 'Cause when I'm broke, I got things.
Kids. Hey, Kool-Aid and frozen pizza. It's the work of art, I ain't talking Mona Lisa. Dream of rocking crowds, see me feeling.
So from a musical standpoint, you can see where the elements of the horns and the other elements that Lord Finesse added was what were likely what Mac Miller used along with the Oscar Peterson chords. I don't know, I wasn't involved in this, and it was settled out of court. But from a musical standpoint, you can see that Mac Miller may or may not have known that Lord Finesse actually got it from Oscar Peterson. And we also don't know if Lord Finesse licensed the use of it from the Oscar Peterson group of owners or estate, or if they did it without permission. We don't know any of that. What we know is that somebody felt that Lord Finesse had been copied. And the lawsuit was really between Lord Finesse and Mac Miller. And I don't know exactly where Oscar Peterson came in. But the reason why this is a good example, I believe, is because really music is put out there by producers in their home studios, many of whom don't have access to the recording labels or industry, but hope to one day. And they put it out in various forms on social media and all, hoping that someone will use it. And then suddenly, you know, they hear something come out like a Beyonce hit, and they think, wait a minute, that's my bass line. Sometimes they're accurate and sometimes they're not accurate when a musical analysis is conducted and a spectrogram of the waveforms that we also look at times. But in the bottom line is that music is floating around. It's being used as sort of a possible asset by others, sometimes without permission, because it's sort of free and floating in the air and can be captured. If you have the right butterfly net, you can perhaps capture it and use it. And then suddenly, if your song becomes big, which is the hope of everyone most everyone who writes a song, or many people, this is what could happen. But it could also be your cello line. Your name could be Yo-Yo Ma or something like that. It doesn't have to be something in the pop sphere. It could be anything that's recorded or composed. Next slide. So now we're moving to today and the sort of recent decade. There, of course, AI has been working within music and other fields of creative arts long before we all became so aware of it with Chat GPT and OpenAI. Presently, they've been working for a long, long time on this, but now it's become sort of publicly accessible. Next slide, please. So something that actually Professor Joe recognized and spoke about momentarily before me, and Professor Fishman, excuse me, but that I also have noticed is that what's really changed is that we're now instead of music occurring at the recording and performance level and being broadcast through all the various forms and utilized and changed through technology, on the internet and streaming and sampling, which kind of promotes a record. Sometimes people feel it's good if their music is sampled because that means their record may have a second life, for example, and distributed and all. Now we're talking about music at the inception, at the creation of the musical work. It's moved back into the inception, and of course, copyright covers the expression of the idea, not the idea itself, including in music. But basically, the AI has become a partial collaborator with the human composer. And this is a new element. And we need to think about that as people who create or perform music, as well as those who enforce the copyrights and the protection of that music. Next slide. So here's an example of not only what you can do, but what is being done probably as we're speaking by probably a few thousand people right now. No. Could you go back, please? Thank you.
This is the future rave sound. I'm getting lost in an underground. This is the future rave sound. I'm getting lost in an underground.
Eminem, bro. There's something that I made as a joke and it works so good, I could not believe it. I discovered those websites that are about AI. Basically, you can write lyrics in the style of any artist you like. So I typed, write a verse in the style of Eminem about future rave. And I went to another AI website that can recreate the voice. I put the text in that and I played the record and people went nuts.
So that's where we're living right now. Next slide, please. And then as Professor Fishman also discussed, the impersonation of a voice is an issue. Of course, it has been for many years since the Bette Midler case and all. But it's not only just a voice, it could be an instrument. It could be a distinctive instrumentalist, for example. Those of you at Eastman may have studied it, and you most likely can recognize, depending on your instrument, well, that pianist is Glenn Gould, but that pianist is Ashkenazi, et cetera, et cetera. Or it could be, a great cellist with a different bowing technique from another great cellist and all. It isn't exclusively the voice, nor is it exclusively in one area, one genre of music or the other, but it can be done and it is being done. And the recording industry is taking it very seriously. So here's an example based on this, what is often referred to as the fake Drake.
I came in with my ex, like Celine, or the flex, bumping Justin Bieber, the fever and left, she know what she need, or she blessed, giving my best, yeah, I got my heart on my sleeve with a knife in my back, what's with that, 20.
Thank you. Basically, this was immediately responded to by the music industry with kind of this very large, sledgehammer. Basically, Universal took it down right away and wanted to send a message, a very, very strong message, as you could read in this slide. I'm not sure that it really curbed the behavior, certainly not on social media. It happens all the time, but this was, I guess it depends on the level of interference with the potential, the artist's potential and that artist standing in that particular record label or publishing company, for example, and the also interference possibly in money or reputation or many other elements probably that go into a decision as to when to enforce and when not to enforce. But when file sharing was at its peak, and finally the RIAA, the Recording Industry Association, decided to take it seriously. I mean, they were suing, I think one of the outstanding lawsuits was against a grandmother who had made some, recordings for her 12-year-old grandchild or vice versa. And, so they were suing grandmothers basically for file sharing, but they were also suing a lot of other big users of it. And I feel like this feels very much like that. But again, it's not just a voice, it's the use of somebody else's material and or qualities in this case to imply that it is in fact that person. And so it's very parallel to the Bette Midler case. But there are also possibilities. Now, remember that there was just a huge strike in California of the writers and actors that impacted the entire entertainment industry for a very long time. And part of those elements of that strike had to do with AI interfering with the livelihoods of actors and writers, as well it already has. Now, some actors decide to take control of that, as James Earl Jones did when he signed a document with Disney, a contract. I don't know if it was under pressure or at his own instigation, given his standing in the industry, to allow his voice to be used after he's no longer acting or perhaps on this earth. So some are taking a proactive approach to embrace the technology and they see it as inevitable, and others are fighting it, as the actors and writers did, in fact, and getting it written into contracts as to how much can be used of their material or replacing them as actors, writers, etc., with this new technology. Here's a little bit about the way in which the voice is used.
Hey, this is James. I'm an actor and this is my real voice. In this video, I'll demonstrate a couple of new features of Reese Features' speech-to-speech voice cloning engine.
Obviously, I can speak with another person's voice.
Another neat feature is singing conversion. Check this out.
Bum ba-dum bum 3 nights at the motel under street lights in the city of palms.
No, I am your father.
So that's what's actually going on, whether whether permission has been granted or not. But it can reach back in time, as I say, with a deceased actor or likeness. So the opportunities are very great and impossible to avoid, but also there are risks for creative artists and their estates. Really, why are we here? Well, part of the reason is because music, even those of you who write very original and great music, but I'm sure you know more than anyone that music can be reduced to metrics. It is, in essence, math from the standpoint of data creation. Everything can be measured: frequency, amplitude, duration, tempo, everything. Everything's broken down into beats and numbers of measures and the exact pitch and range of every instrument and every vocalist, etc., can be completely reduced in a way to numerical information and therefore very, in a sense, very easily learned by machines. They're not real great yet at the undefinable parts of music, the emotional reach and the storytelling that goes on with or without words when it's an artist's personal or imagination, even imagined, even worries or pain or joy, for example. But I think that the next generation of AI will be learning more and from itself instead of from earlier previous musical works, and that's the direction we're going into. And also music created by AI saves the studios and the commissioners of music, whether it's studios or others, creators of advertising, a lot of money on both ends. Because first of all, if they can have something written by a machine, that machine so far doesn't have any right to claim it. So the threat of the rights holders coming after you 30 years after your movie is released, or 5 years or 1 year, because something was used of theirs without permission or a third party, etc., becomes less when it's machine created so far. But the law hasn't really told us, given us that much direction yet. But the music protection system, in which you do have that bundle of rights that Professor Fishman described, is more robust than any of the other art forms, because music, number one, has those two rights, meaning it has both publishing and recording rights in the composition plus the recording and the performance, but it also has a lot of other rights. You can't use music in a moving picture, so to speak, without a synchronization right. And there are also public performance rights if it's broadcast in a public space. Some would say that a ringtone broadcasting on a subway is enough of a public space that you need to pay, ASCAP and BMI and all. So music comes with a bundle of rights and a bundle of individuals and parties that need to be paid. So the temptation on the part of those who eventually have that music in their catalog, whether it's in their film catalog or their music recording catalog, is such that eliminating some of those people needing to be paid or those parties needing to be paid is very tempting, and I just feel it's inescapable. Next slide, please. Music, as most of you know in this audience, is filled with all kinds of pre-existing patterns. Defendants in cases where there is a copyright infringement accusation that a later piece of music copied an earlier piece of music often say, well, it's built on building blocks. No one owns a chords pattern that was just used in the Ed Sheeran case, for example, and no one owns, whatever it is, that rhythm. There are thousands of blues songs written in the blues template. There are thousands of chord series that use just 3 chords in rock and roll, or even 2. There are plenty of songs that end with amen chords, which is basically, a 4 and a 1 and all, which I won't play for this audience because I don't think you really need me to play it to save time. And there are thousands and thousands of waltzes. They have different melodies, and they probably have other different characteristics that enable us to distinguish them, but they may all be written in 3/4 time with the emphasis on the first beat, as based on dance history of hundreds and hundreds of years ago, when that's where the greatest emphasis with the foot and turning out occurred in a waltz, for example, as opposed to something in 4/4 time, etc. So these are pre-existing templates upon which the musical traits are built. And this also makes it a great candidate, though, for machine learning. Next slide, please. And of course, thousands of blues are built on this 12-bar blues progression or something similar. There are others such as 16 bars and all. But basically, this is the template. But within that template is the musical content, meaning the melodies, the lyrics, the actual selection of a lot of other elements, vocal lines and all, that are built on top of this, and kind of on top of this hierarchy of the chords. So that's why we can distinguish one blues from another. And if somebody says you copied my Elvis Presley song without permission, then you have to be talking about the lyrics and other elements that were individualistic with the Elvis Presley song, not the part of the template that the courts now refer to as the Katy Perry case of building blocks. And I say, really, that was why Ed Sheeran's case was successful, because there were 4 chords in common, 3 of which were identical, but they were shown to exist in pre-existing music, which in legal parlance means prior art. So there are some things that are copyright protected and some that are not, basically. Next slide. But all of this still comes down to, what is AI going to do with all of this? And is it actually a co-creator with rights? Next slide. So all of you who compose or perform other composers' music know that it's really a series of hundreds of creative choices that go into the creation of a short form, such as a 4-minute song, or a long form, a 2 or 3 hour opera. And all of these selections on that journey to the final performance, the final musical work, and the final version of it are selections of different options. Should I go from this note up to that note, down to that note, or repeat this note, et cetera, et cetera. And those variables are what are offered to one through OpenAI and through ChatGPT, similar features to ChatGPT, but in a musical sense, similar to prompts when you're texting on your cell phone in a way. And those choices are what are offered in a way that a composer may reach into his or her own musical education and come up with, well, here's how this composer solved that particular musical progression. Would I want to use something like that or come up with something new? Next slide. But it also does enable us to go beyond human potential in some very, very hopeful ways. The MIT Media Lab, with which I work at times, has developed an entire group of hyper instruments, first invented there with Todd Mackover and his work with Yo-Yo Ma and now others, in that the instruments themselves are outfitted with sensors that allow it to respond in real time while the musician is playing, and some of the musicians' bodily and other responses change the music in real time to going beyond what the cello could normally do, or create sounds the cello is not normally capable of doing, etc. So it's expanding the sound ecosystem in a way in real time, and this is also true with vocalists and all. And so I will, and I've just been warned that I should finish up, so I will. We've already talked about the potential for duets with deceased musicians. There have already been many recordings in which this has taken place, but not always with permission, but usually with permission, including finishing a Beatles song, for example, from old tapes of John Lennon, or other kinds of songs. But it could also be to complete an opera that's never been completed yet because of the death of the composer mid-opera, etc. So it has great potential and great risk in a way. Next slide. In terms of the partnership with the healers of our society, such as the National Institutes of Health and all, MIT Media Lab has also worked with them in various forms, including creating a headset for patients with severe paralysis caused by muscular dystrophy, in which the patient can compose music simply by using a headset and some of the sensors and the screen that are available to him, and compose music in that way, even though he is incapable of moving his hands or legs at all, and hear that music. And of course, those with hearing difficulties or physical difficulties in acuity in terms of their hands or cognition are also being helped, including Alzheimer's patients who are now being exposed to frequencies called gamma frequencies, in which the sound itself is helping introduce them to a reducing of their Alzheimer's in a way that no previous therapy or medication has been able to reach. So there are some miraculous parts of AI as well. Next slide. So for the lawyers in the audience and on our panel, the criteria for determining if music has been copied has always been, what, in essence, what's the lay listener, what's the intrinsic test, in other words, the lay listener, the juror, what do they perceive as being copied, which we faced a great deal in the Marvin Gaye case. With or with AI in the picture, does a juror now have to determine, well, that part, the instrumental part, was AI created, so I can't consider that similarity there. But that vocal line and the lyrics, that was written by Taylor Swift or somebody. Is it all right to just look at that? So the courts haven't brought this in line with the criteria that presently exists in terms of copyright protection and disputes about copying without permission. So I guess we do have to stay tuned, and I thank you for your attention, and I'll sign off.
Wonderful presentation. As you could hear, Judith is really an expert about, I won't say all things regarding music, but most, and has the experience to, I think, help us understand how is this going to play out, given how the industry in particular has adapted, and the courts. And between her and Joe Fishman, I think that's a wonderful framework for us to move forward. Did you want to now have some questions? Okay. Our next speaker is Ari Solotov. Ari, like Judith and Joe, is a teacher. He is as was mentioned by Jamal, an adjunct teacher at Eastman, also at Indiana University. Also, I learned at University of Michigan. And on top of all of that, he maintains a law practice. And the law practice is one, as I understand it, that really is a literal arts practice. It encompasses music, it encompasses literary works. It's on the production side, the distribution side. And the reason I was particularly interested in having Ari participate was he can, I think, provide us with a report on what's going on right now amongst his own clients in terms of issues that they are confronting, issues that they're bringing to him, admonitions or warnings that are coming from music distributors, etc. Ari has a background also in music. I know that he was, as a young musical student, an oboe player. He has a degree from my alma mater, UC Berkeley, in comparative languages, from which he went on to becoming an experienced administrator in the classical music world with the Philadelphia Symphony and then in Portland, Maine, and then law school. So his journey has been different than is typical, but has led him now to where he is able to be someone who can provide perspective that's really unique and is something that's very relevant right now to what we're going to talk about. So Ari, I'd like to turn this over to you to talk about AI and what you are seeing with AI in your practice.
Well, thank you so much, Dan. It's wonderful to be here. I started teaching at Eastman in 2019, and what I feel like is that every year I have taught the music and law class in the IML program. I have to keep evolving the syllabus and materials in order to stay up with the rapid pace of change that we seem to be experiencing each year in the music industry, which is not surprising, but it definitely reflects how quickly this is evolving. In fact, in 2019, it had just been a year since the passage of the Music Modernization Act, and trying to digest all of that information as a practicing lawyer and also bring some perspective to the teaching of it was a challenge, but one that I embraced. And actually, that's the reason that I was delighted to accept the opportunity to participate today with you. And I want to offer, I think, those two lenses, the lenses of a practicing lawyer who works in this space with composers and artists and record labels and digital distributors and digital service providers, music publishers, but also just sort of from your perspective, as though I were working with students at Eastman and sort of thinking through how might we approach the subject. And I use that frame to kind of construct my materials today. And so with that, because I'm a practicing lawyer, I have to give the sort of usual disclaimer that these materials are informational and educational. But everyone here is going to have questions, and I would highly encourage you to consult with your own counsel as these issues and questions arise in your own work, because that's really going to be the best way to navigate how all of this impacts your day-to-day and our day-to-day activity as a musician and legal professional in this space. So one of the things that in teaching, and I'm going to try to get through these materials in about 10 minutes, just to kind of give you a heads up. I love teaching the case Whitesmith versus music publishing versus Apollo. This is the case from 1908. It follows from the creation and the invention of the player piano. The decision at the time was that the perforated rolls that were fed into player pianos were not copies, and music publishers, and composers, not surprisingly, got very bent out of shape about this and lobbied Congress for what ultimately became the change in the law in 1909. And I'm thinking actually of Joseph Fishman's image of, is generative AI fair use, and literally like feeding material into the machine and getting these perforated sheet music right out of it. We've been here before is the point. And I loved going back to this case with this lens because sure enough, in the majority opinion, there's this reference to whether or not these mechanical reproductions by the player pianos was a strained and artificial definition or artificial meaning. And so I saw that and thought, oh my God, we have even the early reference of artificial intelligence going back 115 years now. Justice Holmes, Oliver Wendell Holmes, writes a concurring opinion in this decision and talks about really copyright being an abstract principle. And Joseph Fishman and Judith had given a phenomenal overview of the copyright issues here. But the whole point is that copyright is an abstract concept, and that makes it difficult for us to grapple with. And I think it makes it a difficult concept generally. But I think Justice Holmes basically says, in light of that difficulty and in light of the absence of clear lines, the sort of transfer of property, we have to give consideration to the fact that material may be used far and apart from where you originally found it, right? The composer creating it. He goes on to say that this restraint on reproduction is something that is inherent in the nature of copyright. It's sort of the nature of its essence, right? That if you were to copy the essence of the work itself, and I think this is what Judith is alluding to in her remarks regarding, prior uses and the way in which creative expression is ultimately formed, we can't ignore that fact. And Justice Holmes goes on to say, one would expect the protection to be coextensive not only with the invention, which though free to all, only one had the ability to achieve, but with the possibility of reproducing the result, which gives to the invention its meaning and worth. And so in other words, the work itself, reproduced in any sort of method of invention that we can think of, is still valuable. And I think Justice Holmes was alluding to that more than 110 years ago. So I guess I would say this feels like our mechanical licensing moment. This is the moment in time when the technology got ahead of the law again, and it's going to take us several years to sort it out. There may be decisions like the White-Smith case that sort of feel wrongly decided, and it may come down to a legislative solution. So as an attorney practicing in this space, I kind of take a lot of data points. In fact, in our office, we have a shared channel where we post news articles about what's happening in copyright law, to be able to stay up to date on this, the impact of it in the music space. And so I went back and kind of looked at the timeline of kind of how we got here. And it's almost a year. It's been almost a year since ChatGPT launched. That was March 14th. On April 19th, you've heard all about fake Drake. Take note of the fact that it was released on TikTok. The WGA strike, because we're sitting in a broader entertainment ecosystem, began on May 2nd. June 12th, there was an announcement that Elon Musk's former spouse, a vocalist and singer, was willing to split 50% her royalty proceeds in any AI-generated uses of her voice, asterisk that she approves. So you still had to submit it for her approval, but you could get a co-write with Grimes in relation to an AI-generated use of her voice. June 18th, the Grammys announced a rule change saying that if you submit something that was 100% AI-generated, you're not going to be eligible for a Grammy Award. The strike ends in September. And then October 18th, Joseph Fishman alluded to the Concord Music case, is sort of how long we went from fake Drake to about 5 months or so before that emerged. And then we moved into 2024. We have an open letter literally on January 30th, the day before the TikTok license expires. And in the open letter, UMG points to the fact that it is in fact TikTok's allowance of massive amounts of AI-generated recordings that are flooding the platform, and their enabling of that material. That is in fact one of the issues that led to them deciding to take the stance that they did regarding the TikTok license. February 1st, TikTok removes all of the UMG artists and recordings. In the middle of all this, the AFM has begun and concluded negotiations with the AMPTP regarding use of their musicians in motion pictures, and residuals and AI were certainly part of that. And then yesterday, 6 o'clock in the morning, news breaks that TikTok again removes now not just the recordings, but UMPG publishing as well from TikTok. So they're taking steps actively to work through and think about and try to draw pressure against UMG and its companies. So again, as a professional in this space, it's been really hard to keep track of kind of all the moving pieces and all the different products and companies. And so I started to think about, is there a way to organize this information that I could explain to my clients? The Anthropic case you saw, that's a text-to-text case involving lyrics. Alphabet, Google, right, has a product called Lyria. Microsoft has Jukebox, the OpenAI AI research project, which is an text-to-music production. Meta has AudioCraft, text-to-music again. And then there are other companies that have entered the space, right, that have allowed for music AI generative tools to be used. Boomi being one, so text to music, and they actually offer a royalty split with their the individuals who participate in the platform and distribute their AI generated music. 80% to the writer, 20% to Boomi. Boomi still holds the copyright under license from the author. Clangio, another one, performance, right, instrumental performance to sheet music notation, and then music flow, text to audio production. So this is a fast moving, these are just some examples of the ones that I found in this space, but they're out there, right? And they're happening in relation to the AI platforms and systems of which Joseph and Judith and others have alluded to. So here's the Concord Music case and context, right? We had the Anderson versus Stability AI, which is an image case. We then had the Silverman versus OpenAI and the Authors Guild cases, which are book cases, and then the New York Times case. And so the Concord Music case is unique in so much as it's actually sitting in Tennessee on a motion. The complaint was brought on a motion for a preliminary injunction, whereas the other cases are class action suits. So we may see some interesting movement, I think, in the Concord Music case, because of its procedural posture. But I went, and as I talk about in our class, I really love going and looking at the complaints themselves. If you're interested, I would encourage you to go to Court Listener, which is a free resource, to actually go see the court docket materials. And so here's an excerpt from the plaintiff's complaint, Concord Music and the various publishers, who say, look, at the end of the day, the use by Anthropic here of all the songs, and including Born to Be Wild that Joseph referenced, right, does not comport with the fact that there actually is a pre-existing market here for lyric licensing, and the fact that publishers have been in the business of lyric licensing for quite some time. And this is actually a really important point when it comes to kind of countering the argument, the fair use argument, that there isn't a market, and therefore there would not be the fourth factor in terms of market harm. So they're going straight to that issue in this case. The response, the opposition motion, you'll appreciate the response here. Anthropic does not want the lyrics of the plaintiff's works to be output by its AI models. This is almost sort of a passive position, as it were. The purpose of the training on the data, including the songs, is not to reproduce the lyrics themselves, but to learn general ideas and concepts about how the language works. So it's essentially saying, like, that's not the objective here. The objective is to teach the model, and the fact that it happens to reproduce these lyrics in the form that it does is not the volitional intent that would lead to a showing of infringement. This is not a case where the defendant stores complete infringing copies of the plaintiff's works and then produces them on demand. That's not the result, right? You don't go to these and say, that the copy then results. It just happens in their position that this is not a simple database of training content, but rather a massive compilation of correlations between text prompts and content, largely stored as conditional probabilities, right? These are the systems and training models and weighting that then at the output stage, as Joseph alluded to, in response to a user prompt, uses those probabilities to predict and generate essentially a reasonable response. And therefore, that's how we end up with the lyric licensing. Even if it doesn't satisfy the volitional copying element, the question of fair use is, whether or not, in this case, the courts in the past, and there is precedent for fair use to be applied to these essentially intermediate copies, right, that are being used to train and included within the training materials to then develop new technologies, which in court precedent has, particularly in the Second Circuit and the Authors Guild case, has been held not to be an infringement. So that's the backdrop that we're sitting against. So the copyright issues have been defined in the text-to-text cases, in the case of lyric licensing or lack thereof, as infringement, but also there have been counts and claims of removal of DMCA, removal of copyright identifying information, which is actually a separate claim under copyright. And I'm going to come to this in a moment when I talk about the practical implications, but it's called a 1202 claim, and removal of copyright identifying information is a separate claim beyond infringement. Joseph Fishman and Judith have talked extensively about the right of publicity law issues that are separate and apart because of our patchwork of state laws that govern rights of publicity. We don't have a federal right of publicity. And so that is also creating some of the ambiguity in the system right now. There are also state law privacy rights. There's claims of unfair competition under California law, and then potentially state contract law issues to the extent that the models were trained on scraped material from essentially breaches of terms of use of these websites. And so there's other issues that are going to play out beyond the copyright issues. Joseph Fishman alluded to the Midler case, and I love also, in addition to that case, the Waits versus Frito-Lay case, which is, I think totally prescient. Tom Waits basically brought suit against Frito-Lay for the unauthorized use of his voice in connection with the Frito-Lay commercial, of which he was adamant that he never wanted to appear and have his music used in a commercial. So it's a really wonderfully instructive case, I think, and is very timely to the issues at hand. And then one other thing that I think has not come up inherently, but it comes up, I think, in my work in recording contracts, is the question of our album artwork. Who's going to own this album artwork if it is generated by an image generator? And how do we work through that question as well? I mentioned the fact that the entertainment industry is not as siloed as it used to be. In my own practice, I do work with WGA writers. And one of the questions that came up under the 2023 MBA settlement was, well, what about AI? Well, there's a section in the MBA that I was really curious to read that has to do with the acknowledgement, essentially, in the settlement that this legal landscape of GAI is uncertain and rapidly developing, and that in effect, the writers and the AM Motion Picture Association were reserving all their rights relating to AI, and that no party would be prevented from asserting that the exploitation of their literary material to train, inform, or in any other way develop GIS software or systems is within such rights and is not otherwise permitted under applicable law. And so there was essentially a strong reservation of rights on both sides to sort of see how this plays out. And I think that's instructive in some way as to how there's a bit of a wait and see approach while the law and policies continue to evolve. This then came up again the day before the UMG announcement. There was an extensive article in the New Yorker about Lucian Grange. And what caught my eye here was, and I think this hopefully will turn us to the ethical questions, was the YouTube principles put forward by Neil Mohan, the CEO of YouTube, who essentially identified 3 principles of ethical AI in relation to music and said, number one, that there should be a commitment to the responsible use of AI in collaboration with music partners. Number 2, there should be considerations of safety and internal guardrails that are built into the AI systems. And then 3, to Judith's point, that there will be technologies that will be created to help identify through content ID systems whether or not AI material has been utilized or employed. So to bring it home here, the practical questions that I think about in my own practice is, particularly from the rights holder or talent side, musician side, back to basics, prioritizing copyright registrations. To the extent that that has not been factored into your own practice and into the practice of those that you work with, to me, that still is the basic element, because I think establishing a public registration, not only is it a precondition to suit, but it's also going to be, I think, a mechanism for affirming rights. Getting a sense of one's own assets, right? What do you have and what are you creating and where are you in your own chain of title analysis? Doing due diligence on, submission of musical material to third-party websites, reading the terms of use to determine how material is being used. Has a company adopted ethical AI policies in relation to submissions? There's another element of this, which is called RAG, Retrieval of Augmented Generation. Retrieval Augmented Generation, which is essentially these prompts going out in supplementing their responses with live material. So you can imagine, a tool going out and then, pulling information, for example, I don't know if this is happening, off of SoundCloud. A musician posts a demo to SoundCloud, they incorporate that in, and all of a sudden it's part of their new musical profile. And so just being mindful of where one's material is going. And then to that point, the inclusion of copyright identifying information in the materials that are being produced to preserve that potential claim under 1202. And then I'm also seeing the use of the idea of a no AI metadata tag in the files themselves as a way of kind of signaling, to these scraping data sets that there is sort of an intent not to have material included within an AI training data set. Back to the similar basics of looking at compensation, credit, and control as it relates to the material that's been created in connection with AI. And then also, this same question of whether, in the WGA case, whether Gen AI uses are in fact within the initial transfer or intended within the license that was granted, or need to now be expressly included within the reservation of rights clauses. Finally, the contractual disclosures that are being made when a party enters into an agreement that talks about material being original and not infringing. And then similarly, if using third-party music, will individuals be subject to third-party restrictions on the development, training, or use of unauthorized training materials, and how that gets defined? And then lastly, I think the music industry, again, may be leading the way here, but or may have led the way here, but the 2018 Music Modernization Act led to the Mechanical Licensing Collective and a collective licensing model, and whether we're really just heading for kind of a much broader consideration of a collective licensing or opt-in model or opt-out model under either a compulsory licensing scheme or voluntary licenses in that space. So that's my general distillation of the issues here as it relates to both practical considerations and thank you for the opportunity to participate.
Thank you, Ari. That was a wonderful report from the front lines, as it were. It's astonishing just looking at your chronological rollout, how quickly so much is rolled out in the 21st century from where we were. I remember when I was practicing law back at the dark ages, around 2005, when digital projectors in theaters were being resisted. There were many advocates for them, and there were many reasons to have digital projectors because you could avoid having to send prints around to theaters, which was expensive. But they cost about $35,000 per theater, and the theaters were resisting, and the studios were resisting, and suddenly it happened over like about a year. The studios finally said, you know what, we will save a lot of money. And so they took on the cost. And we're seeing some of those same kind of very rapid transitions with respect to how AI is going to be first identified, whether systems are going to be generated that will enable users, audiences to know what's being done with AI, and also ultimately the compensation system in the industry to make adjustments. Well, the next speaker is going to be our, we would say in baseball, cleanup hitter, Jonathan Harrington, who is an assistant professor at University of Rochester with many connections. He is in the Health and Humanities and Bioethics Department. He also has, through a joint appointment, a professorship or assistant professorship of philosophy. And his research is in political philosophy of science, health, and technology, a broad-sounding area which touches upon our subject matter, ethics, and the ethics involved in understanding artificial intelligence, adapting ourselves to its usage, but also creating controls, or at least guidelines, that will allow those who AI is passed on to understand whether they're getting something from AI and how it should be approached and understood in the context of our knowledge. So, Jonathan, I'd like to turn this over to you. Thank you for being part of our panel.
Thanks so much, Daniel. I'm going to ask Daniel to please keep me to 10 minutes, ruthlessly keep me to 10 minutes so that we have some time for questions. So I'm going to talk to you a little bit about the high-level ethical risks of generative AI. So we're moving away from the legal context here, and instead we're going to be talking about sort of the key ethical values that we might appeal to when thinking about how we ought to act when we place to one side the kind of legal context. So imagine what we're doing is perfectly legal, and now we're asking ourselves, ought we do the thing that the law allows us to do? And one way of thinking through the different ethical issues here is to sort of break things up into three buckets of value. So, traditionally moral and political philosophers think about questions arising around whether or not our actions are respectful of the personhood of the individual agents or stakeholders that we touch or interact with or affect? Right, that's one question. And mostly that revolves around whether or not that is respectful of their autonomy, of their dignity, of their property rights and basic liberties. Next, we might turn to ask ourselves, is the technology something that makes users' lives go better? Is it something that makes us as a society better off in terms of our lives going better? And then the final bucket of things that we might care about are questions about the distribution of benefits and burdens between people. So we might say that a particular technology benefits most of its users, but is that distribution of benefit and burden mostly towards people who are already well advantaged? And does most of the burdens accrue to people who are less advantaged? Okay. Those are the general kinds of areas. And what we're going to do is going to do a very quick tour through some considerations in each of those value domains. So the first thing that comes to mind, and I should say, part of this analysis is informed by work that my colleagues, Rafael Barassi, Ben Guerrero, Blair Kerner, and Rachel Roberts did as part of the NSF funding, which is that they went and talked to working composers and musicians about their fears. And part of that involved talking about the ethical questions or concerns that come up. So you will see off to the side or throughout these slides little text boxes with quotes from working musicians about their feelings. So one of the things that's come up already is, whether or not the uncompensated use of scraped musical training data violates a property right that creators have. We've talked about the legal context there. I'm going to actually say that from an ethical perspective, that is mostly a legal question, right? What actually counts as a property right is mostly the kind of best way that we understand property rights in a moral context, is that it's mostly a legal convention about how we've decided to assign a system of incentives for creating value in the world. And in general, it looks like there's a kind of unclear ownership of the data that is used in music, right? And there's this long history of covers and remixes and imitation. And this seems to be sort of similar to that from a moral perspective. But I'm mostly going to leave all that to legal scholars to figure out. So that's kind of unsettled. But even if we settle the question of whether or not a particular piece of uncompensated use of a particular piece of music to train these models wasn't theft, we might still ask whether it's a form of impermissible exploitation. So we're all familiar with kinds of exploitation. They're typically things that involve a kind of legal contract where someone has voluntarily entered into some kind of arrangement with another person. And yet we have a kind of feeling that the terms of trade in that interaction are so unequal that it becomes a kind of moral wrong for the dominant party to impose or accept that contract, right? And I think a lot of people want to say that in the context of generative AI, where the owners of these large language models and generative AI models engaged in music are just reaping a much larger share of the gains of trade than the artists, right? The artists basically get nothing, and the owners of the LLMs get this fantastically valuable tool. And you might think about it, some theorists like Tristan Goetze have suggested this is kind of like a kind of form of digital colonialism, where the ownership of a particular set of resources might not be precisely defined within a community, and might be hard to allocate to individuals within that community. But an outside party coming in and expropriating all of those resources for its own benefit might nonetheless be a kind of moral wrong against that community as a whole. Okay, A second form that we've talked a lot about is this form, a second form of disrespect that these generative AI models might generate is a kind of misleading non-misleading impersonation and a kind of dignitary harm. So this is, I think, a particularly good example of, and different from some of the others we've seen, where this is a cover Johnny Cash, an AI model of Johnny Cash doing a cover of Aqua's Barbie Girl. And it's labeled as an AI cover. It's not designed to mislead, but nonetheless, given what we know about.
I'm a Barbie girl in a Barbie world. Life in plastic, it's fantastic. You can brush my hair, undress me everywhere.
So I hope you're able to hear that. We might think that this is a kind of violation of Cash's autonomy. Whatever the legal context of the use of his personage shakes out to be, we might say that this is a kind of puppetry of Cash that violates their control over their own person. And that's pretty clear. It's pretty clear that we think a kind of puppetry of a person's body would be a gross violation of their autonomy, right? And I think what we need to settle is what the status of people's voices are, right? Is your voice you, or is it simply a kind of image? And whether or not you have a moral right to control your image if it is just your image. The other way that we might think about it is it might undermine people's dignity. So even if it doesn't undermine their control over their person, you might think that it's a form of mockery or degradation or humiliation. And we might think that that kind of AI puppetry is nonetheless kind of impermissible. All right. The one final thing that I'm going to talk about for 1 minute before we break for questions is the question of bias in these models, which we haven't really touched on because it's not a question that comes up in the context of legal questions. But what we know is that these models are trained on a mostly Western corpus of music. It encodes a particular musical style. In particular, you can think about the kinds of tuning systems that we use in Western musical traditions. And what that means is it's going to be less useful for less dominant musical styles and cultural traditions. And this has been a point that's been raised by the British composer Kiam Alami, who has actually generated a kind of transcultural generative AI system for creating that uses different tuning systems from around the world as the kind of basis for the generative AI model. I encourage you to kind of look up the Apatone model if you're kind of interested in this. Alongside that question of unequal performance, right, we have this question of whether the training sets, because they're trained on a particular Western style and that is overwhelmingly what's in the training data, they're going to reflect particular social stereotypes, right? And so we worry about the ways in which these kinds of models, when you ask them simple questions, when you ask them to produce output, especially text to media models, that they're going to reinforce stereotypes about the social identities that are associated with particular musical styles or genres, right? So if you ask one of these models to create a pop song about relationship angst, right, it will invariably give you a kind of female singer, right? Ignoring the fact that George Michael's Wham, right, that George Michael's Wake Me Up, right, is a pop song about relationship angst. Similarly, an indie rock song about skateboarding, right, is going to invariably give you a male singer, notwithstanding that Avril Lavigne and artists of that type have been singing about this kind of thing forever. And so there's this worry that, these kinds of models, even if we're doing something legally permissible, are going to really reinforce particular social stereotypes. And I don't really have time to go into this, but we can talk a little bit about what we ought to do about this and what kinds of principles we can follow. There is a set of principles that were developed by a music journalist, Sarah LaRue, which I really like. It's worth looking at, that say that you ought to use these models for creativity with integrity and in solidarity with people. And I've also developed a set of principles for the users of these models that try and specify a little bit more what LaRue's thoughts really mean in concrete terms. And I would love to talk with folks about ways to mitigate these kind of ethical questions in the Q&A.
Thank you very much, Jonathan. We will return, if we have time, to questions relating to that so that we can pursue those questions you just raised. We're going to go now with the remaining time that we have to our Q&A part of the program, because we did invite our audience to submit questions, and many of them have. So I'd like to start by directing one of the questions, which was specifically directed to either Joseph Fishman or Ari Solotov, or both. They can both talk at the same time, presumably. This goes to the question of infringement. Question is, does the crucial distinction on the input side rest on that between the economics of the use, i.e. the commercial use, for example, publicity voice, versus some kind of fair use, whether it's commercial versus, let's talk of, say, non-commercial? Or is there an element of the technical AI part, distinction, say, between data informatics, learning general ideas, that informs the meaning of infringement? Hopefully you can understand my translation of that question. Let's start with Joe.
Yeah, I'm happy to take a first crack at it. And I think I also just answered a version of the same question privately in the chat to the person who came up with it. If I understand the question, it has more to do with the economics than the technical architecture on the fair use side. So the technical architecture of generative AI models matters a lot for establishing that copying has occurred, right? That's the training process. Once we know that, the fair use question that would excuse any copying that has occurred, that cares much more about the market impact of the use. So in this case, the use is copying for purposes of training data, and that's going to be this comparison of purpose. Is the purpose of the developer behind the AI model the same or similar enough to the purpose of the original artist's expression? And I think, this is my opinion, but I fully expect that the big fight there is going to be in how we characterize what that second comer's purpose is, because there are different ways that you can try and frame, right? Is this just copying for the purposes of producing a new market alternative to the original song, right? The original song was a pop song, and this training is going to enable the production of yet another pop song? Or do we characterize the purpose differently in terms of just pattern recognition and mining the metadata of the work rather than a new expressive use? So I hope that answers your question, but on fair use, I think it's going to be more in terms of economics than it is in terms of the technical architecture.
Ari, what about your perspective?
Yeah, I think Joseph has done a brilliant job of summarizing the issues. So I guess I would just say it's highly technical and highly case specific, and so I'm not sure that we here are going to be able to draw some broad generalities because of the multiple layers of complexity as you saw. So I'm happy to hand it back to you to tackle another question.
Okay, another question. If AI reproduces a song I wrote, will I get any money for it? Let's ask the copyright professor first and then Judith.
If AI reproduces a song that you wrote, will you get any money for it? Well, let's leave aside whether anybody wants to pay you any money for it outside of AI, right? It might have to do something to do with like the quality of the song, but I think we have to divide between on the input side and on the output side, as I was talking about earlier in asking that question. If the copying is happening on the input side so that your song was part of a training data set that includes millions or billions of other individual works, maybe not. Liability to begin with is very far from a sure thing, but even if there were liability, like what percentage of that overall training set, right? What damages have you experienced that are attributable to copying your specific work? That's going to be a bear to try and sort through. So that's one difficulty. On the output side, there's maybe a better case there. And I know, Ari was talking about registering your works. If you've registered your work, right, you might have a claim for statutory damages, which could be worth something even for a single work. But if you're just trying to prove your actual damages from a memorization where the AI has just regurgitated your work verbatim, my guess, just like going off of what I imagine the average work would look like, is that there's not going to be a lot of money at the end of that rainbow, but your mileage may vary. That's my take.
Anything to add, Judith?
Well, Joe distilled it beautifully. I would just add that sort of from the analysis standpoint, if this became an issue, a dispute, it would need to be filtered between the human, between whether or not it was completely replicated, like a complete copy, sort of the memorization concept, or was it changed by the AI? We're sort of the idea that I showed you of sampling. I mean, that's what happened with sampling and hip hop recordings, for example. If they use something they wanted to be recognizable, like a famous song sung exactly by Ray Charles and using his particular vocal qualities, etc., that's one thing. But if they changed it and made it sound like now it was sung by a mermaid or something, but it was the song, like you have to filter it between what the criteria are and what was done to it and changed.
So here's another question. I think we'll have to wrap up the Q&A section with this question. One of the points that the Copyright Office has made in their preliminary statements about what they're going to do about artificial intelligence has been to point to the Constitution and the so-called intellectual property clause and say, well, from that and also case law, particularly the Ninth Circuit, it's well established that copyright protection extends only to human beings, a human being who is the creator. The question is, since the clause itself doesn't really say that quite so specifically, is that necessarily going to be the case with the courts? Certainly the Copyright Office is taking that position. I'll just read from the clause. Congress shall have power, amongst other things, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings. Well, that doesn't say human beings. we used to think that free speech applied only to individuals, only to learn about 10 years ago that now corporations have a recognized right of free speech. If artificial intelligence, and I think the problem that many people have here is separating out who's controlling the artificial intelligence from the artificial intelligence itself. Do you think it is really in concrete that artificial intelligence not controlled in some essential way by a human being is going to be prohibited from protecting that, whatever it creates using artificial intelligence? What do you think, Joe?
So, is your question whether there's a world in which the machine can be deemed an author itself?
Well, I mean, from a linguistic standpoint,
Yeah.
the constitutional clause doesn't really answer the question.
Right.
I guess what I'm asking is this something Congress and or the courts are going to have to settle, or are Congress and the courts going to say the Constitution governs?
Yeah. So the provision of the Constitution that you read speaks of authors and writings, and the way that the Supreme Court has interpreted those words, though you're correct that it doesn't say this expressly on the face of the text, is that authorship necessarily requires humanity. You cannot have a machine author. You cannot have an animal author. If you're an author, you're a human being. Now, what's interesting, you brought up corporate speech. The US is something of an outlier on the global stage in that it's fine with corporate authorship, right? We have works made for hire in the United States where authorship vests initially without any transfer, without any assignment in a corporate entity, if it meets the statutory criteria. So we seem to have made peace with the idea that an individual human being does not need to be an author. You could have a corporate author, but it's still at least a collection of human beings. So just descriptively, I don't see either Congress or the courts saying that a machine could be an author. And my quick take on that is that it's a good thing, because I don't think we need copyright for machines, right? Copyright is supposed to incentivize investment, and machines don't need incentives. Human beings do. So I'm happy with where the law is at right now, but that's just my personal take.
Okay. Well, thank you very much. We've run out of time, sadly, but I've enjoyed very much all of your comments, and I hope our audience has as well. Rachel, again, thank you to Institute for Music Leadership and Eastman School of Music for sponsoring this. Hopefully, we'll have more opportunities to talk about this whole subject matter as it evolves, which seems to be very quickly. Thank you again. Thank you all for joining us. And we look forward to you joining subsequent programs of Institute for Music Leadership.